Hello everyone and welcome to Module 4. Module 4 is going to be one of the heavier weeks, I'll say, because it's talking about medical law and ethics, talking about HIPAA, and the electronic health record. So knowing all of those things that we're going to be talking about, it really breaks down into two chapters. It's going to be Chapter 13 and Chapter 14 for this week. So let's go ahead and jump in and let's start talking about these two chapters. So we're going to start with Chapter 3, which is Medical Law and Ethics. And when we talk about this, it has 4 different classifications or categories that medical law can be broken down into. Those are criminal law, civil law, international law, and military law. Now, only 2 of these really are going to relate to medical and medical law. Those are your criminal and civil laws. So those are what I'll focus on for the video. But I would still tell you it's really important to know about international law and military law. Now, criminal laws are laws that are made to protect individuals and the public as a whole from harmful acts of others. Criminal acts fall into 2 categories, and those are felonies and misdemeanors. Felonies are acts that can carry punishment of either imprisonment in a state or local prison or the death sentence. Some examples of felonies could be things such as murder, rape, robbery, or in the case of medical, practicing without a license. Misdemeanors are less serious offenses. They carry a punishment of either fines or imprisonment for up to 1 year. Some examples would be traffic violations, disturbing the peace, or even theft. But again, with medical, it would be examples such as maybe prescribing medications illegally or stealing prescription pads. Now, when we talk about criminal law, a physician's license is something that can be taken away if they do commit a crime. For example, they could commit sexual misdemeanors or misconducts, murder, or violating narcotics laws. However, medical assistants do not have a license, and we work under a physician license. So what that means is while we work under that physician license, we still cannot diagnose our patients. If we're trying to diagnose or treat a patient, we can also be fined or even prosecuted even though we don't have a license. So please make sure that you understand your state's scope of practice and that you as a medical assistant cannot actually diagnose a patient. Now, the next one is a civil law. And civil laws are laws that concern the relationship between individuals or between individuals and the government. Civil laws are broken down into 3 pieces, or 3 different types. They can either be tort laws, contract laws, or administrative laws. So tort laws are laws that cover acts that result in harm to another. In the medical world and medical law, this means that you must cause damage or injury to a patient. The injury or the damage must be caused by the physician or an employee, such as that of a medical assistant. Charges for tort laws can be called either unintentional or intentional torts. Intentional torts are things that you do intentionally without the patient's consent. Things such as assault, battery, false imprisonment, defamation of character, fraud, or invasion of privacy. Unintentional torts, though, could be labeled as neglect or negligence. In order to prove negligence has occurred, the plaintiff or the patient must be able to present the 4 Ds of neglect. Those are duty, dereliction of duty, damages, and direct cause. Contract laws are laws that include enforceable promises or agreements between 2 or more persons to do or not to do a particular action or service. A contract between these parties must be composed of 4 parts. They must have an offer, an acceptance, a consideration, and a competency. All 4 need to be present in order to make that contract legal. And lastly, we have administrative laws. These cover regulations that are set forth by governmental agencies. Most healthcare employees are more frequently going to be part of contract laws or tort laws, so I don't want to touch too much on administrative. But laws that can fall under this area are violations against HIPAA or violations of Medicare or Medicaid fraud. One other piece to Chapter 3 that I want to discuss with you is going to be malpractices. Now, a malpractice is an unreasonable lack of skills that result in an injury, a loss, or a damage to a patient. Malpractice claims really are classified according to 3 types. They are a malfeasance, a misfeasance, or a nonfeasance. A malfeasance is when you perform a wrongful act or an unlawful act. A misfeasance is where you perform a lawful act, but not in the proper way. So the best example I can give for that would be if you knew that you, as a patient, had to have your right foot amputated, and when you woke up from surgery, your left foot was amputated. They did a rightful act, but they did it in the wrong way. And a nonfeasance means neglecting or ignoring or refusing to perform a necessary lawful act. So again, for example, if you know that a patient has gangrene and needs their foot removed or their toe amputated or whatever that might be, and you refuse to do that. Now lastly, I want to talk about HIPAA a little bit. And HIPAA stands for the Health Insurance Portability and Accountability Act. It was a law passed by Congress in 1996. The purpose was to seek improvement on efficiency and effectiveness of healthcare systems through insurance reforms and administrative simplifications. Simply put, that means that all patients have the right to their personal privacy being respected and their medical records being handled with confidentiality, meaning that no information can be told to another person without the consent of the patient. HIPAA gives more control to the patient for their overall health information, and medical practices are required to notify patients about the uses, disclosures, and rights of their protected information. As a medical assistant, you must always be vigilant about protecting patient information. HIPAA requires that all medical employees undergo training during orientation. This training is organized into 3 parts: privacy regulations, transaction standards, and security regulations. And typically, that will happen within the first 30 days of employment. So that's it for Chapter 3. We're going to move on to Chapter 14 here. And Chapter 14 is talking about the electronic health records. Now, as a medical assistant, it's important that you understand and know what an electronic health record is, why it's important, and how it is used. Electronic health records are computerized versions of a patient's medical history, and they take place of what used to be paper charts. The EHR provides a computerized meaning of gathering, documenting, and storing information about the patient and the care that the patient has received. Electronic health records also allow access to patient information by multiple physicians and hospitals through the use of networking and communication. Now, generally, we do refer to the electronic health record as an EHR, but it wasn't always called that. In fact, when computers first came into the medical facilities, it was referred to as computer-based medical records. As computers gained popularity and newer software was developed, it transformed into the EHR or EMR, electronic medical record. This then got adopted because it was able to describe the ability to share computerized information among providers, which was widely adopted by the Institute of Medicine of National Academies in 2003. Since then, and computers have been around since the 1960s, Mayo Clinic was actually the first one to start using them. But ambulatory clinics were slow to adapt to this area and this idea. The whole purpose of an EHR is to strive to make healthcare safer and allow better communication between the teams. In 2009, Congress passed a law for the first time that made funding available for the EHR. The HITECH, or the Health Information Technology and Economic Clinical Health Act, was put as part of this law. It included financial incentives for providers who adopted and used the EHR to demonstrate the ways to improve the quality, safety, and effectiveness of care. This law then came into terms known as meaningful use. It is referred to a set of criteria for how the EHR are used that providers must meet incentives in order to receive the payments. The criteria include improved quality, safety, and efficiency, engaging the patients and families, improving care coordination, and improving the public health population, as well as ensuring privacy for personal health information. So what are the benefits to actually using an EHR? Well, one of the key benefits is that it can be created, managed, and consulted by authorized providers and staff across multiple health organizations. Other benefits would include improved diagnostic and patient outcomes, improving documentation, especially when the provider had terrible handwriting before. It allows them to document more quickly and more consistently and in more detail. It improves care coordination, which leads to better communication between staff members and a better outcome for our patients. And it helps to avoid medical errors. So the EHR will actually alert healthcare providers when there is a possible medication error, when the patient has something that they're due for, such as routine procedures, mammograms, pap smears, physicals, colonoscopies, things of that nature. And again, helps to decrease the problems with illegible or unreadable handwriting by providers. Alright guys, so that's kind of the wrap up of chapters 3 and 14. For this week, you do have one discussion post looking at HIPAA and confidentiality. You're going to have to list a couple of places in the clinic or other facilities where HIPAA gets compromised and how you can prevent that. That initial discussion post will be due Tuesday, July 25th by midnight, and at least one reply post to your classmate is due Saturday by midnight, which will be July 29th. You do have another course project VIS summary, and that's over the MMRV. That's measles, mumps, rubella, and varicella. So make sure when you're looking them up, you get the correct VIS. Again, make sure you're reading the rubric that's already up in the Course 4 module over what information should be included in your summary. That will be due Sunday, July 30th by midnight. And you do have one quiz again this week. It is multiple choice, 20 questions, and you will have a 30-minute time limit. That as well will be due on Sunday, July 30th. Now, additionally, this week you do have a mid-quarter student survey. If you could please just take a few minutes out of your day, fill out that survey so that way we can get good feedback about how you feel about the course, about me as the instructor, and how you're feeling about Rasmussen in total. That helps us to adjust our program and our courses to best fit the needs of our students. As always, guys, if you have any questions or concerns, please reach out to me either via Blackboard email or my direct line on campus, which you can find on your course homepage right by my picture there. And I hope that you all have an awesome and amazing Module 4. Bye, guys.